Good afternoon, everyone, and thanks for checking into the webinar this afternoon on understanding relocation matters in family law. My name's Stephanie Brown. I've been a solicitor at Michael Lynch Family Lawyers for 3 years doing family law matters. So this is just a brief overview of what we're going to be running through today. We'll be talking a little bit generally about relocation matters, some of the statistics that come from the cases, and then we'll go through some general parenting law stuff as it applies to relocation cases. So talking about parental responsibility and parenting arrangements and going through the court process. And then we'll also go through a case review of about 4 recent cases dealing with relocations. And then there'll be just a bit of a what to do at the end of that if you do have clients come in and talk to you about these issues. So there is actually no specific legislation that deals with relocation matters. It's just dealt with under the usual family law parenting provisions in the Family Law Act. So the court must rely on the usual parenting pathway set out in the Act, and then they just apply that law to the specific facts of the case. So we just need to, I guess, as there is no specific legislation dealing with this, we do look to the cases a lot to look at how the court may deal with certain issues. It's particularly difficult in relocation matters because the facts of each case will differ dramatically, and each of them is so unique depending on the parties involved and the children involved. So it is quite a difficult area of law to give, I guess, a certain answer on. Some of the statistics that came out of a 2011 study by the Australian Institute of Families looked at a number of the cases that had come before the courts and just gave some general statistics. So usually it's the mother that is wanting to relocate with the children. That was the case in 88% of the cases they looked at. The majority of relocation matters end up before the court are usually described as high conflict and do quite often also involve allegations of domestic violence. In the cases that they looked at, 57% of the applications for a parent to relocate were approved, and of those, parents relocating back to their birthplace or their hometown were approved 75% of the time, and parents relocating to be with a new partner were approved 54% of the time. And we'll talk a little bit later in more detail about some of the reasons that people relocate and how that factors into the court's consideration of parenting matters. So although it's not a unique area of law and that there's no specific legislation for it, it obviously does pose a whole bunch of unique issues for courts when they're looking at these matters. So the best interest of the children and how that conflicts with the interest and the right of the parent to move on and live their lives is really why these cases create such headaches for lawyers and the courts. And this is a quote from one of the cases by Justice Kirby. One of the objects of modern family law statutes is to enable parties to a broken relationship to start a new life for themselves, to control their own future destinies, and, where desired, to form new relationships free from unnecessary influence from a former spouse or partner or from a court. So that's obviously the parent's position, is that they should be able to have freedom of movement. But unfortunately, when we're looking at relocation cases, that does defer to the paramount consideration of a child's best interest, and if the child's best interests are adversely affected by the move. So that's that conflict, and it's quite unique in family law matters that the court is considering that conflict. The other difficulty in relocation cases is that there's usually no middle ground for negotiating. It is quite a positional, the relocations are quite positional in nature, because there's one parent saying, I want to relocate to this place with the children, and the other parent generally opposing that application, saying, no, it's not in the child's best interest and it's going to affect their relationship with the child. So these two different positions really do make them difficult cases. So due to that, obviously one party is either going to have to concede on their position, or it will have to go through to a final hearing, and the court will determine whether to approve the relocation. So unlike when we see parenting matters, generally a lot of the time, if they don't end up in court, or if they do end up in court, they don't go through to a final hearing because people are able to negotiate on their position and reach some agreement that they think is in the best interests of the children. With relocations, it really is a kind of all or nothing approach. It's very hard to find a middle ground. So often, unless a party does concede, it will have to go through to a final hearing, and that's the only way it will be resolved. So as I said before, we'll talk a little bit about reasons. So some of the big ones that come up are returning back to a hometown, moving closer to family support, moving to live with a new partner, or employment reasons. Now, there is, as I said before, there's no specific legislation dealing with this, so the court doesn't technically have to deal with what is the reason for a parent relocating. However, obviously, practically, this is going to come into considerations as to how a relocation will work if it's approved, and what the implications may be on the other parent if it's not approved, and how that may affect a child's welfare as well. So for example, if a parent is making an application to relocate to live with a new partner, the court's going to consider, okay, does that provide additional care and support? Are there step-sibling relationships that will be of benefit to that child, and also the happiness of the mother in that case and how that may affect her parenting capacity. Similarly, if a parent is applying to move back to their hometown, looking at things like the family support that will be positive for the relocated parent and the child having an opportunity to have relationships with extended family that they may otherwise not have had, and again, the happiness of the parent that's been able to relocate. And I've put mother in there because, as I said before, it's usually mother, but obviously it equally applies if it's a father's application. So generally, relocation matters will come to the court's attention in one of these two ways. So the first is if a parent is wishing to relocate with a child, they make an application to the court to approve that relocation, and that can be done either before or after they've moved with the children. Obviously, if they have unilaterally relocated with the children, that brings a whole other different set of issues with it, but it can be done afterwards. Or a parent has relocated unilaterally with the children, and the opposing parent brings a recovery application in the court for the children to be returned to their former residence, and with that, then usually there's a response from the other parent saying that they think it's in the best interest of the children to relocate to that town. So that's usually the ways it comes to the court, and we'll talk about parental responsibility and why that's an issue now. So as I said, the legislation that applies in relocations is just the usual parenting path that courts go through when we're looking at what parenting arrangements to put in place. So we'll go through a little bit those legislation sections, and then we'll talk about how they apply in relocation matters. So the court starts from the presumption that it's in the child's best interest for separated parents to share responsibility for decision making about major long-term issues. So that's things such as religion, name, education, health, and a child's living arrangements, and that's referred to as equal shared parental responsibility. So obviously the major one that we're looking at in relocation matters is where a child lives, if that time will affect the child's time with a parent. So that's generally a decision that should be made jointly between mums and dads usually, as to where a child is living, if it's going to affect their time, and that's the issue that comes before the court in relocation matters. And just a note there that the presumption of equal shared parental responsibility can be rebutted in circumstances of family violence or abuse, and that's something that the court would consider as well when these matters came before it. So the best interests of the child is the paramount consideration that the court's looking at in any parenting matter, and including in relocation matters. So there is no presumption that operates either in favour of or against relocation, and the court just needs to look at the best interests in that particular case and what the best interests of the child are. So that's the paramount consideration when they're looking at parenting arrangements. So the court must weigh up the options in relation to parenting arrangements, and uniquely, I guess, in family law matters, that can include considering options outside of the parents' competing proposals. So they don't necessarily have to stick to mum says X, dad says Y. They can actually look outside of that and come up with arrangements or orders that serve the best interests of the child, which may not have been one of the proposals put forward by the parent. So best interest is the overarching principle, and the court determines the best interest of the child by looking at the primary and secondary considerations under the legislation at section 60cc. So I'll go through those with you now. So when the presumption of equal shared parental responsibility applies, the court has to consider, first of all, is it in the child's best interest to spend equal time with each parent? And is this reasonably practicable? If they say no, that's not practical or that's not in the child's best interest, then they then look to the next step, which is, okay, equal time is not appropriate. Is it in the child's best interest to spend significant and substantial time with the other parent? And is this reasonably practicable? And then if that limb fails, then they then look at, okay, what orders are in the child's best interest, taking into account the primary and additional considerations, which we'll go through. So obviously, in a lot of matters, relocation matters, equal time isn't going to be something that's practicable in the circumstances, because usually we're talking about significant distances between parties and where children are living. So equal time is obviously 50-50 shared care. Substantial and significant time is defined to include time on both weekends, holidays, and school days, and allows a parent to be involved in the child's daily routine and occasions and their special events. So that's usually time during the week and on weekends for both parents to be involved in a child's routine. And when the court's looking at what's reasonably practicable, they need to consider how far apart parents are living, which is obviously the big issue generally in relocation matters, parents' capacity to implement the time arrangements and their capacity to communicate to resolve difficulties that arise, the impact of the arrangement on the child, and any other relevant matters. So the court does have quite a broad discretion to look at any other matters that may come up in a specific case. So when we're looking at the primary considerations under that section 60cc of the Act, the first primary consideration is the benefit to the child of having a meaningful relationship with both of the parents. And then obviously the second is the need to protect the child from any physical or psychological harm and family violence. So that's the primary considerations the courts are looking at. Then there's a whole bunch of additional considerations, including that general one that the court can kind of look at any relevant circumstance. So any views expressed by the children, taking into account the child's maturity and understanding. And I'll talk a little bit more in one of the cases later about child's wishes and how that's taken into account. But I guess it's important to remember that there is technically no age at which a child can tell the court or choose which parent they live with, and it's just one of the considerations. And that's, I guess, a common myth out there generally in the public, is that children have an age at which they can choose who they live with, which just isn't the case. The nature of the child's relationship with each of the parents and any other person, such as grandparents and relatives, the extent each parent has taken to participate in decision-making, spending time and communicating with the child, the likely effect of a change in circumstances for the child, including separation from a parent or relative, practical difficulties of spending time and communicating with the other parent, and expense or difficulty of that time. And that's something we'll talk a lot more about as well later, particularly in relocations where you're talking about plane flights and international flights and things like that, and I'll talk about that more later. The parent's capacity to provide for the child's emotional and intellectual needs, the maturity, sex, lifestyle, background of the child and the parents that may be relevant. If a child is Aboriginal or Torres Strait Islander, the right of the child to enjoy that culture and the impact of any proposed parenting order on that right. Any family violence, including consideration of any family violence orders, the circumstances of the order, the evidence admitted in those proceedings, and any findings by the court. Whether an order should be made that would be least likely to lead to further proceedings in the future. And as I said, just a general discretion in that the court can consider any other fact or circumstance that may be relevant. So when the court's looking at, I guess, these best interests, how do they actually get that evidence? And particularly when we're talking about, I guess, child's wishes. So the court isn't got the, I guess, children don't give evidence in court and they don't give affidavits in court generally. It's just not, I guess, appropriate in the way the system works. So the evidence in relation to best interests and particularly child's wishes generally comes from one of, I guess, four ways. So affidavit evidence of a parent or other witnesses during legal proceedings. Often in parenting matters, we do get a family report done, which is done by a social worker or psychologist, and that social worker or psychologist will interview both of the parents, the children, and any other new partners or anything that are involved in lives, and they then write quite a detailed report to the court. But it's important to note that although the family report writer will give recommendations as to what arrangements may be in the best interest of the child, and because they have spoken to a child, that sometimes includes a discussion about what the child's wishes are in that particular circumstance. That's not actually binding on the court. It's just one of the considerations that the court can look at when they're looking at what's in a child's best interest. The other way you can do it is if there's been an independent children's lawyer appointed, and that's often appointed by the court in matters where there's, I guess, a need to represent the child's best interest particularly. The ICL isn't actually instructed by the child, but they are there to act in the child's best wishes and sometimes, best interests. And sometimes the best interests of the child can actually conflict with the child's wishes. And it just depends what other evidence is before the court. And the other way we can get evidence is obviously just by subpoenaing schools, medical records, counselling records, and things like that. So that's the other way the court can look at and have evidence before it about these issues. Okay, so we're going to go and look through some cases now, and most of them are fairly recent cases that we're going to look at how the court may apply this. And this hopefully will give you an idea of how difficult this area of law is and how complicated it is, because each matter is so different and the facts are so different, and often the end result is quite different as well. So we'll look at, the first one is McCall and Clark. So I've just given a little bit of background. A lot of these are also appeal decisions. So they've been decided by a child judge in the first instance, and then one party has appealed them and a full court has made a determination. So that's usually, I guess that's the best evidence of the law being applied, because a full court has considered it. So in this one, the child was 4 at the time of the appeal. The child had been born in Australia, and when the child was quite young, so only 6 months old, both the parents and the child travelled to Dubai. And I think the intention was that they were going to get married over there, and before they did that, they actually broke up over in Dubai. So at first instance, so the original trial judge made orders for the child to live with the mother in Dubai, and then made orders that the child spend time with the father. And there was, I guess, alternative orders that provided for the child to spend time with the father if he was living in Australia, and then also if the father returned to Dubai to live. The father appealed those orders on the grounds that the judge did not properly consider the legislation, and in particular did not consider the child spending equal or significant and substantial time, and failed to consider how the child could maintain a meaningful relationship with the father. So that was those, I guess, the legislation provisions that we looked at before that provided for equal, when you've got equal shared parental responsibility, which they did have in this case, is equal time going to work? If not, is significant and substantial time going to work? And then also looking at how it's a benefit to a child to have a meaningful relationship with both parents. So that was the points of appeal. On appeal, the full court found that the judge had noted that the father was able to move to Dubai if he chose to. However, the court did not consider the possibility of the mother relocating to Australia. So that's looking at, I guess, proposals outside of what the parents may have proposed, and whether any of those arrangements are actually in the child's best interest. The full court also found that the judge did not make a finding about the impact of a move to Australia, which was not the mother's preferred residence, and any impact on her parenting. So that's looking at those competing proposals and whether that's in the best interest of the child, and also found that the judge failed to properly consider the benefit to the child of having a meaningful relationship with both parents, and how the orders would affect the child relationship with the father. And I guess that was particularly relevant because of the young age of the child as well, when they had separated, and the bond or otherwise that the child had with both of the parents. Given the importance of international relocation decisions, expert evidence may be important to give evidence about the long-term consequences for a child. So in this case, they didn't actually have a family report or an ICL appointed, which they usually would, and I spoke about that evidence before. So it was difficult to say, I guess, long-term what the consequences would be for a child's development and the ongoing relationship with the father, because that evidence just wasn't before the court. So the father's appeal in that case was allowed, and it was sent back for a rehearing before a trial judge. The next case that we're going to look at is this one of Malcolm and Munro. In this case, so this was one, I guess, where the court restricted a mother from being able to relocate outside a certain area in New South Wales. The child was aged 8 at the time and was not actually the biological child of the respondent, but has been raised as that person's child from birth. So during kind of the course of mediations and negotiations, it came out that he wasn't the biological father of the child, but he obviously was an important person in the child's life and had seen that person as his child from birth. So was still able to apply under the legislation for parenting orders. The parents lived in different towns in close proximity, and the child was spending 40% of their time with the respondent and otherwise lived with the mother. So obviously spending some significant and substantial time with the respondent. The mother had repartnered and then unilaterally relocated with the child to Town W, where her new partner lived. She gave reasons to the court for her relocation, that her sick father was residing in that town, along with her disabled brother, and she wanted to be able to care for him. She took compassionate leave from work so that she could obtain work in Town W, and obviously also her partner was living there as well at the time. So before the final hearing, the mother applied for a permanent position with her employer in that town, which was actually refused. So once it was refused, the mother actually relocated back to the town she originally lived in, and returned the child to their previous school as well. So the court ordered that the mother be restrained from causing the child's residence to be outside the New South Wales district where Town T was located, so basically within the general area of where she was living with the child and where the respondent father was living as well. The court did not believe the mother's reasons for her relocation were sincere, especially as she had a home in T. She had moved back there after she couldn't get employment in the other town. She had employment in Town T where she was. And the court also mentioned that the biological father of the child, and that had only kind of recently come out, also lived in Town T. So if the child did want to explore a relationship with the biological father, she would be able to do that as well. So the mother's appeal against the orders was dismissed by the full court, and the orders remained restricting her from leaving that, well, restricting the child from leaving that district. I guess the court's not necessarily concerned with where parents live, but obviously as it's relevant to where children live, that's what the court's concerned about. Okay, so the next case is Wendland and Wendland. There was one child involved in this case who was at the time spending 3 nights each fortnight with the father, and then also doing kind of after school afternoons with him as well. They were both mum and dad were living in the same town in Queensland. The mother was employed by the Defence Force, and she had been employed with them for 18 years. So the mother made an application to the court, seeking that the court make an order to allow the child to live with her. And I guess it was a bit unusual in this case in that she was seeking a quite general order that the child be able to live basically wherever she was posted with the Defence Force, which does, I guess, have its own issues with it, because as we'll talk about later on, there's a whole bunch of practical considerations that should be considered when we're looking at relocations, and it's quite difficult to do some of those things when you're not sure where the town is that you're going to be living in. There was evidence that it was a condition of service under the Defence Force that members were available to be posted, and if she told the Defence Force that she couldn't actually be posted anywhere, that could result in her dismissal. So the court considered that the child and the father had a close bond and they would continue to having a meaningful relationship even over a long distance. The relationship could still be meaningful, the court said, even though it was not necessarily optimal. The impact to the mother if she had to leave the Defence Force was quite significant. Given the length of time she'd been employed by the Defence Force, it was a part of her identity, and it may affect her parenting capacity. Employment options would likely to be limited, and she would likely, if she had to leave the Defence Force and gain employment in the town she was, it would likely that would be on a lower income as well. And the court also looked at the intent of the legislation. And if you remember, we talked about the additional considerations before. One of those is whether the court should make orders that will mean that the matter doesn't come back to the court's attention later on. And the court kind of looked at that and said, right, well, it's not practical for her to have to keep coming back to court each time she's posted to another town, which could be fairly regularly. And therefore, the wide orders allowing the child to relocate with the mother where she was posted were made by the court. In this instance, the father did appeal that decision, and his appeal was dismissed. So those orders allowing the child to live wherever the mother posted remained in place. And the final case we'll look at is a recent High Court decision of Bondelmont and Bondelmont. So this was quite an interesting one, particularly given the age of the children, and I spoke about wishes and ages before, so this will give you a good indication of that. So in this case, there were 3 children aged 17, 15 and 12 years old. Parents kind of separated in 2010, and then there were consent orders filed in 2014, which provided for the parents to have equal shared parental responsibility, for the children to live with the mother and father, and quite general orders as agreed or as requested by the children. So they didn't actually provide for any specific time as far as I could tell from the case. The oldest 2 children, who were both boys, elected to live with the father. The eldest child was estranged from the mother and hadn't spent time with her. The middle child was living with the father and spending limited time with the mother. And the youngest, who was a girl, was actually living with the mother. In January 2016, the father said to the mother that he was going to take the 2 boys to New York for a holiday. Just before they were due to come back, the father then told the mother that he was going to stay in the US and that the boys wanted to stay there and live with him as well. So that in first instance, the trial judge ordered that the children be returned to Australia, and that and again, this is, I guess, kind of a unique one. There was an argument that the children, if they were forced to return to Australia, didn't want to live with the mother. So the court made orders that if the father did not return to Australia, the boys could live at a friend's house or in supervised accommodation paid by the father if they weren't living with the mother, which was a little unusual. The father appealed that decision to the full court. The full court said, no, there's no reason to appeal. And then the father then appealed to the High Court. So the appeal to the High Court, basically the father's position was that the judge had failed to pay proper attention to the wishes of the children to remain in the US with the father and did not allow the matter to be adjourned. So the father had asked that it be adjourned so that he could get a wishes report done in New York, and the court had declined to get that done. So in this case, the High Court held that the wishes of the children were already evident in the material, and it wasn't necessarily the mother's case that she disagreed that the children did want to remain in the US. The issue before the court in that case was then the weight to be placed on those issues as one of those, additional considerations that we talked about before. It's only one of those considerations that the court needs to look at. So the father was quite well off, and and the court made a comment that this may have been telling of the father's attitude. So he'd flown the boys to New York business class and then booked them economy flights back to Australia. So I guess when you're looking at a 17 and a 15-year-old, that probably gives you a fair indication of how the father may be influencing them to stay in the US. The court also made a comment that the father had a tendency to consider the wishes of the children as decision makers. So he was kind of the view that this is what they want to do, so they get to make the decision. And as I said before, that's not the case. Even if they are 17 and 15, the court can make orders up until the child is 18. The judge also spoke about the fact that the children had given very little thought to the separation and its effect on the relationship with their mother and sister. And that also comes down to, maturity of the children and what influence the fathers had as well. And that's something the court needs to look at. So the High Court held that the trial judge had considered the wishes, but had discounted those wishes in circumstances where the father had impacted the children's views and had encouraged their wish to remain with him. And as I said, some of that seems to have been financial, although that wasn't specifically said. It seems like the dad was pretty cashed up and may have been influencing them to stay there. So the appeal was dismissed by the High Court, and the order for the children to return to Australia remained in force. So that gives you an idea of when the court needs to look at wishes, but it's just one of those factors that the court looks at. So let's talk about some practical considerations in determining best interest in relocation cases. So as I said, relocation cases aren't a, defined category of case, but because we need to look at the best interest of the children, it's important to have some evidence about what the practical implications are of the relocation. So the court can better consider what the actual effect is rather than this kind of question mark unknown effect of relocation. So things like the distance between the two proposed homes, the actual logistics of travel, if it's car, if it's plane, if it's multiple planes, and particularly the age of children and whether they can fly unaccompanied. And that may mean, they may be able to fly unaccompanied on airlines given their age, but also the maturity of the child to actually deal with that, which might be very different across different ages for children, particularly where you're talking about international flights. Whether the other parent, so if you're relocating, whether the father usually can travel to the child rather than have the child travel to him, what the accommodations options are, what, hire cars, all those kind of things, and whether that means that the father could be involved in more school activities and things if that's practically going to be an option. The cost of travel and the finances of parties and how realistic are the proposed travel arrangements. And that's something that's important to consider, particularly when you're talking about young kids. People tend to think about these things in short term and think, oh yeah, if I'll pay for the flights, but if that's going to be an ongoing obligation until a child is 18, it can be quite taxing, particularly if financial situations change or employment's lost and things like that over the years. And then also looking at whether the other parent could relocate to the new proposed location. So again, employment opportunities, visa if it's international relocation, all those practical things to look at. And the other things to think about when you're looking at best interests are, the impact on parents and their relationship as well, and how that may affect children's relationship with parents. So looking at the relationship between parents, there's usually flip sides to these things. So in one sense, conflict may actually be reduced when parents are living separately because it means they're not interacting as often. But on the flip side of that, if parents have really poor communication, it may be that they actually are unable to facilitate a relationship over a long distance. And again, that's going to come down to the age of children as well. If children have their own phones, Skype, email, it may be that the parent doesn't need to be super involved in maintaining that relationship with the other parent. Very different story if you've got quite young children and a parent's unable to communicate with the other parent, then that's going to make it really hard to facilitate that relationship long term. The mental health of parents and how that may be affected by relocations. That's looking at, if they're moving closer to family, that may be improved. If they're living in an isolated town because dad's working in an isolated town and they'd like to get out of that, how mental health may be improved. Flip side of that is if they are living near where the other parent's living and they're doing a shared care arrangement, then if they're going to move away and they don't have any other care options, doesn't mean that the children will actually be living with them full time as opposed to 60% of the time, and that may have a negative effect on their mental health. The happiness of the primary carer is obviously a significant factor in the well-being of children, and we spoke about that a little bit in some of the cases as to whether a parent's capacity to care for children may be affected if they're either, I guess, forced to stay in a town that they don't want to stay in, or they move and they may not have that support from the other parent. So, as I said before, less time with the father may mean more time in her care, and how does that affect parental capacity? And it may also affect employment opportunities and things as well if you've moved away from a parent who's able to assist with care arrangements. What are the proposals for the child to spend time with the other parent, and are these practical? So sometimes that looks like a parent having all of the school holiday time if they're not having time during the school term. But is that sufficient to maintain the meaningful relationship? And does that work for that other parent as well, depending on what their employment may be? Are they going to get the quality time during the school holidays? And then also looking at the loss of the father's involvement in the day-to-day care of children and not being able to be at significant events and school events and things. And that's looking at the effect of that on the children. Just a little bit touching on, I guess, relocation as opposed to child abduction. So relocation cases are a result of a parent wanting to relocate and seeking orders from the court to allow the move, or a non-resident parent seeking orders for recovery of a child that has been moved without permission. When we're talking about child abduction cases, that generally involves a parent removing a child overseas without the other parent's permission. That obviously has a whole other raft of issues associated with it. We don't have time to cover all those today. Basically, there is recovery processes in place for children that have been removed overseas, and that's going to depend on whether the country is a signatory to the Hague Convention. When countries are a signatory to the Hague Convention, means that we have reciprocal agreements with them to recover children back to Australia. When there are non-Hague countries, it becomes much more difficult, and it probably depends more on the law of that particular country. So that becomes really difficult, and obviously is a whole other, it becomes then a jurisdiction question of whether Australian courts have a right to deal with it and how long it's been. So that's a whole other webinar really to talk about. If a child is moved within Australia without a parent's permission, there can be recovery orders, and there can be recovery orders as well if a child is overseas. There is a question of jurisdiction then. So if a recovery order issues for a parent in Australia, the federal police will, if a parent doesn't return voluntarily, will go collect a child. And that's usually done pending a further order. So where a parent has unilaterally relocated with a child, a recovery order will be made, and then it will become an issue for the court to consider long-term what parenting arrangements are in the best interest of the child, including whether they're living in X town with the parent or in Y town with the parent. So that's usually one of the issues that comes up. So what to do, I guess, I hope I've given you an indication of how complicated relocation matters can be, and they are quite difficult and unique due to the issues that do come out of relocation. So I guess the first thing to say is people should get legal advice early on. Having a plan may improve the prospects of success because it means it's been thought out, and should always have legal advice prior to unilaterally relocating with children. So I guess it's best if you have a client that's thinking of relocating, it's best to have the application to the court made before they've just up and done it without the other parent's permission, because I guess you're then coming to the court with clean hands. You've done the right thing. You've been upfront about it. It's a bit more difficult to relocate and then have the other parent make the application, and then you're kind of on the back foot. Although obviously the court's still only going to look at what's in the child's best interest, but it may just show that some of those communications between the parents aren't optimal, and that may affect then what's in the best interest of the children. Plans can't be, I guess, half-baked, so you've really got to think through all those realistic financial arrangements. What does it mean? How is it going to look for the kids? Even things like researching the schools and daycares in the area. Can you afford housing in the new town? Really practical things. I guess, the court doesn't want to see this grass is greener mentality. So yes, we've separated, but I'm going to move to a new town and everything's going to be fine. That's just, I guess, not practical in the sense of being able to maintain that relationship between the children and the other parent. So you've really got to think realistically about it and think about what that may mean. One of the comments in an article I read when I was researching this was that parents kind of saying to children, okay, we're going to relocate to this beach town because we holidayed there and we like it. Holidaying in a town is very different to kids going to school in a town, finding employment and all those things. So it needs to be a thought out plan rather than something that's just come up on a whim to try and, you know, start a new life. Really important to communicate with the other parent, and that's in any parenting issue if possible. It's really important to have that communication open and find out whether there's a way to resolve the issues and come to an agreement without the need to go to court. And as I said before, it's really hard in relocation cases because it's basically we're moving, no you're not. But whether there is some kind of agreement, maybe the other parent isn't wedded to living in the town they're in and they're happy to relocate to a town nearby, or maybe, you know, there's somewhere halfway that they're happy to do changeovers, and that's a better option for everyone. So if you can have that communication, I appreciate often that's not necessarily possible in a lot of these high conflict cases, but if there is a way to have that discussion, whether that's with a counsellor or with a mediator, then that's good to have. As I said, there's no formula or rules to be applied necessarily to relocation cases, and each case does raise its own unique set of facts, and I guess a lawyer needs to give advice specifically about what those facts are, because that can mean a very different outcome each time. And thinking through, I guess, the competing proposals of mum and dad and looking at whether there is that third option potentially of, you know, a town nearby or a town halfway, or dad's happy to move, all those things should be canvassed. I guess it's very easy for people to get stuck in their position, and sometimes it just takes some creative thinking, and you might be able to come to some kind of agreement that works for everyone and particularly works for children as well. Okay, so that just about wraps it up. I think we've actually had a question through on the chat, so I'll just quickly read that. So the question is, just to clarify, there isn't an age that the child can choose which parent they would prefer to live with. So that's the question that comes through. Yes, that's 100% correct. There is no age. A lot of people, or we hear a lot that people think the age is 12. I don't know where that's come from. The weight, as I said in that case, that Baldermont case is a really good example. There's no age at which a child can say, this is what I'm going to do. Obviously, the older a child is, potentially the more weight will be given to their wishes, but it's just one of those additional considerations that the court can look at. So it's certainly not determinative. If a child is saying, I want to live with dad, that doesn't matter. Basically, the court can make orders up until a child is 18. So hopefully that answers that question. If there's any other questions, I've put the email up here, so if anyone wants to flick an email through to that, they can, and I can either email you back or call and answer those. There'll also be a feedback survey popping up once we've finished up the webinar and closed it down. So we'd really appreciate if you could give some feedback about the webinar and how it went and what you thought of it. That would be great. It just helps us when we're planning future webinars. And if you do have clients come in and you're looking to refer them to a family lawyer, then these are our contact details. We do a fixed fee initial consultation, and there's no obligation to engage us beyond that, and the fees are just up there. So we're more than happy for you to pass our details on. I really hope the webinar was helpful, and thank you so much for tuning in today. And like I said, look forward to getting your questions and feedback through later on. Thanks very much. Have a great afternoon.